Hello and welcome to the ICC Annual Arbitration and ADR Conference. We're just letting people get access to the platform and we'll be making a start very shortly. Thank you. Hello and welcome to the ICC Annual Arbitration Conference. Glad to see everyone today. We've had a real international audience for this morning's webinar. We had over 340 people now registered for the three-day event. So it's great to see so many taking part virtually. I'd like to hand over to Brandon, who is our moderator for this session. Before he takes to the stage, I just wanted to remind everybody that the live discussion is now available. If you'd like to add your questions for our speakers, it's open throughout the session, so please do add your questions to the live discussion, and they'll be posed by Brandon throughout. The session's also being recorded and will be made available after the event as on-demand content and can be accessed via the virtual platform. So without further ado, please welcome Brandon to the stage and who will introduce the rest of our speakers. Thank you.
Well, thank you, Natalie. Good afternoon, everyone. My name is Brandon Malone. I'm a lawyer and an arbitrator based in Edinburgh and London, and I have the great pleasure of being a member of the ICC UK Arbitration and ADR Committee and also a member of the ICC Commission on Arbitration and ADR. I also chair the Scottish Arbitration Centre, and I will momentarily abuse my position as the moderator of this session just to tell you that the dates for the 25th ACA Congress have moved again due to the ongoing pandemic, and it will now take place 18th to 21st September 2022 as per the logo beside me. So MedArb, the best of both worlds or an unnecessary intermediary? This is the question that our panel will explore today. Mediation and arbitration, two very different forms of dispute resolution at what might be considered to be the opposite ends of the dispute resolution spectrum. On the one hand, we have arbitration, which is a formalized process involving the application of the law to the facts of the case in an adversarial setting. It's an adjudicative process with a decision being imposed by the tribunal, the parties having submitted to the jurisdiction of that tribunal as a matter of contract or perhaps as a function of a treaty. Mediation, on the other hand, is a consensual process. It focuses not on the disputed issues of fact, not on the disputed law, but on the parties' needs and interests. The mediator does not impose a decision on the parties, rather he or she is assisting the parties to reach their own agreement. Now, there are some who say that arbitration and mediation should never be mixed, or at least I know a few mediators who take that view. But of course, most of us will regard arbitration and mediation as tools in the dispute resolution toolbox, along with litigation, expert determination, and all the rest. Now, there's nothing particularly unusual in attempting a mediation during a formal adjudicative process, whether it's arbitration or litigation, either in parallel with that process or in a gap or a window during proceedings. But what about MedArb, which is a process in its own right? That's what we're here to discuss today, and we're very fortunate to have with us an excellent panel to do that, and I'll introduce them now. So we have Hannah Ambrose. Hannah is a senior associate with Herbert Smith Freehills with their international arbitration team in London. Legal 500 has identified Hannah as a rising star. We have Clea Bigelow-Nuttall, who is a senior associate with Pinsent Masons in London, specialising in commercial and investment arbitration. Clea has practiced at the Paris Bar as well and is fluent in French and English. We have Mark Morrill, a hugely experienced top-ranking arbitrator and mediator based in New York. I have had the privilege to know Mark for a number of years as we've worked together on the ACA New York City Bar CPR working group on cybersecurity and international arbitration. And finally, we have Tek Wee Tiong, a Wong partnership based in Singapore. Singapore, of course, is a real hotbed of dispute resolution innovation. So we look forward to hearing TechWe's perspectives and insights. So we'll start with the questions. And the obvious question, the first one is, what is MedArb as opposed to having mediation during an arbitration, within an arbitration? And can it legitimately be described as the best of both worlds in terms of ADR mechanisms? I'd like to take that one first.
Brandon, I'll jump in there if I may, and thank you for that introduction, and thank you also to Natalie and the ICC for the opportunity to speak to you today on this topic. When it comes to talking about MedArb, I think practitioners will tell you that there are as many forms of MedArb as there are disputes between parties, with the differences as to the timing and position of mediation in the dispute resolution process, the identity and the role of the neutral, and we'll hear more about some of those variations of MedArb today from the speakers. But at its most basic, what we're talking about today is the hybrid process in which the same neutral party takes on the role of mediator in the first instance during the mediation, and then subsequently becomes the arbitrator if the mediation process doesn't result in an agreed settlement. And this I might refer to today as MedArb solo, in the sense of having a sole neutral, just for ease of distinguishing it from the other forms of MedArb processes. And in order to understand whether MedArb can be described as the best of both worlds, it's helpful to go back a bit and remind ourselves what some of the key criticisms of arbitration and other ADR methods are that MedArb might seek to address. In 2019, Queen Mary University London, together with Pinson Masons, carried out a survey to consider how the process of resolving international disputes could be made more efficient. And while that survey was set in the context of international construction and infrastructure disputes, the issues that arose in terms of parties' use and perception and choice of ADR mechanisms were readily translatable across all different industries and sectors. And from the widespread of data, the results very conclusively showed that the majority of respondents, more than 70%, all preferred international arbitration above any other tool. But while arbitration was the leading mechanism, the perception was also very clear that it took too long and it cost far more than it should to pursue an arbitration to a final award and sometimes to enforce that award. So there was this really clear message from users that they wanted to see resolution of disputes, which are often very complex, very technical, in a more cost-effective and a more time-efficient manner. So there's this appetite for users of ADR to address the time and cost concerns of arbitration. And those concerns, I think, have driven some important developments in mediation in recent years, particularly in the form of the Prague Rules and the Singapore Convention. In 2018, the Prague Rules on the efficient conduct of proceedings in international arbitration aimed to create a more efficient process and reduce costs. And Article 9 of those rules, under that, the tribunal is empowered to assist parties in reaching an amicable settlement. And should they agree in writing, a member of a tribunal can also act as a mediator and can indeed continue to act as an arbitrator if the mediation doesn't result in a settlement. So this is effectively kind of the precursor to this solo MedArb that we're discussing today. And in a similar vein, we then saw the Singapore Convention on Mediation developed in 2019 and come into force in 2020, which seeks to provide a legal framework for settlement agreements resulting from mediation. Now, it's only been ratified by a handful of countries so far, but we're undoubtedly going to see that increase. So it's in this context where the idea of MedArb as a tool could be a really good hybrid to address some of the inefficiencies that we've seen be criticized in arbitration. And I think its advantages may too often have been overlooked because of what we're going to hear about in terms of some of the main risks regarding confidentiality and possibly double hatting that we'll discuss today. But I would say that it's a very good place to start, and it possibly is at least the best of both worlds as a starting point for a few reasons. First, it gives very clear time and cost savings to parties. Mediation, even in the most complex cases, is a notoriously quicker and cheaper process than a full-blown arbitration, and it has very high success rates, meaning that there's a good chance that parties will avoid costs and time of arbitration altogether. And in the event that a mediation doesn't conclude with an agreed settlement, then there's the ability of the arbitrator to put on their decision-maker's hat and pick up the thread with full understanding of the facts and the issues, meaning that no time is lost and no expense is wasted, getting a new set of neutrals or a tribunal up to speed. The fact that in MedArb, an arbitration follows the mediation as part of a pre-agreed process then serves to kind of give parties certainty about the process. They can engage in the mediation knowing that this is the first step, but the buck doesn't stop there. If a settlement's not reached, the parties then can proceed on to an arbitration and to have that final binding award. I think MedArb also allows parties the chance to get to a settlement with their relationship intact. And I know that Techwe has some thoughts on this that he'll share. But many of us have no doubt experienced of situations where the moment an arbitration is commenced, parties go into litigation mode. And every letter written or procedural exchange between the parties in a formal arbitration context, the prospect of a settlement, let alone a continued business relationship, slips further away. Now in MedArb, if there's no settlement in the first phase of the process, the parties will at least have already been in dialogue with each other. And so an arbitration may well be less litigious, less acrimonious, and more efficient. Now, I don't think that these factors alone necessarily make MedArb an absolute perfect solution or fit for all parties and all disputes, but I think it is a good starting place to be discussed and considered, and one that might be somewhat overlooked for the time being.
Okay, thanks, Claire. Well, let's drill down into that a bit. Now, Techwe, as I say, Singapore, an innovator in this area. What are some of the advantages you've seen of MedArb in practice?
Thanks, Brendan. Thanks, Claire. Just to pick up from where Claire left off, I totally agree that some of the key advantages of MedArb would, of course, be time saving, cost saving, narrowing down the differences between the parties, even if mediation is eventually not successful and parties still have to go through arbitration. So these are certainly some of the key advantages of MedArb. I think in practice, the key point that I would like to highlight is that no business, no commercial business is actually in the business of litigation. Litigation, I think, is really one of the for lack of a better word, most dreaded outcomes for most businesses, because it takes away time, it takes away effort, it takes away fund, resources, away from other efforts that they can plow into more profitable and more productive activities and businesses, right? So I think in terms of the advantages of MedArb in practice for businesses is huge in the sense that it allows for dispute resolution. It allows for hopefully a agreed or binding outcome on the dispute, and it allows businesses to move on with their core activity, which is to do business and to make money. So that to me is the key advantage of MedArb in practice. Other advantages I think in practice of MedArb would, as Claire alluded to earlier, the ability to allow parties hopefully to preserve their commercial relationship moving forward post the dispute. A lot of commercial parties are often in long-standing commercial relationships with each other, sometimes with long-running contracts spanning 20, 30 years. And when a dispute occurs, the commercial relationship or the contract may just be in its early years, say the 5th or 6th year, right? And I think this we especially see in industries such as energy production, where power purchase agreements typically have lifespans of 20, 30 years, or we see this in the case of, for example, commercial leases, where likewise you may have lease agreements spanning 9, 10 years. So you do have these very long-standing and long-running commercial relationships that it's necessary for parties to preserve in order to move ahead with the relationship post the dispute. And I think MedArb steps in. This is where MedArb is advantageous in that it allows parties to come to hopefully an amicable resolution and settlement of their disputes and move on from there, right? Arbitration often, even amongst the most gentlemanly of counsel, arbitration often has a more acrimonious element to it, especially when you have witnesses put on the witness stand, questioned about their decision making and the way they conduct business. And whether you like it or not, witnesses sometimes take things personally, and that spills over into their relationship with the opposing party post the dispute. Even if they get an arbitral award in their favor, they may not have been happy about being put through the ringer and that translates, that spills over and taints the commercial relationship after, right? So another one of the key advantages of MED up in practice would, to my mind, certainly be the ability to allow parties to preserve their commercial relationship post the dispute and to move forward with that. So yeah, I think that's my take on the key advantages of MED up as seen in practice. I mean, there are of course a lot of other advantages that one can certainly think of, especially on the time and cost saving front that Claire mentioned earlier on. But yes, those would be the two key advantages in practice, really.
Thank you very much, Degri. And this the fact that you have a structure procedure that's leading you automatically into mediation perhaps overcomes that reluctance of some parties to show weakness by suggesting a negotiation before going to arbitration if it's built in, I guess. So, but it's not all milk and honey necessarily. So Mark, Hannah, what are the potential pitfalls for the unwary of this process?
Let me start out with that end of it, Brandon. Hannah and I agree with much of what our colleagues have said. It's hard to argue against efficiency, of course, innovation, of course, time and cost saving, of course. Litigation is generally a bad outcome, whether it's in the courts or in arbitration, although I do see actually a fair amount of arbitration that is brought for business strategic reasons. But generally, I think it's not a good result. But our subject today is not all of those good things. It's MED-ARB, and whether MED-ARB is the most useful tool in the toolbox. I think Hannah and I would agree that it's potentially a tool in the toolbox. Our view, though, is that it's not quite the bright, shiny object that some might think it is. I think that the principal argument in favor of MED-ARB is that the feedback that the profession sees from users or clients, as we might call them, of the arbitration process is consistently supporting innovation. Understanding the risks of innovation, including MED-ARB, and a willingness to accept the risks in pursuit of efficiency and cost savings and preservation of relationships. So, for example, the Global Pound Conference, the worldwide series of meetings and surveys that concluded 2 or 3 years ago, 45% of the respondents supported the mixing of modes of dispute resolution and bringing innovation into the process, with the recognition that non-adjudicative modes of dispute resolution, such as mediation, could be done sequentially in parallel or integrated with each other. But still, we think from all of that the strong message was in favor of innovation and cost savings. We think that MED-ARB in particular presents some significant risks and drawbacks. We also think that better innovations, better tools to integrate the adjudicative and non-adjudicative processes have emerged. And interestingly, the pandemic has shed some light on very useful alternatives. So with that, I'll let Hannah start to talk more specifically about some of our views.
Thank you very much, Mark. Yeah, I completely concur with the points already made, and a lot of what Tekri in particular was saying about the benefits of mediation itself resonate with me. But I think ultimately what the parties really need is certainty that they're going to have a binding and enforceable outcome. And I think that's my starting point, that the enforcement risks regarding mixing of the roles in that particular way, where you have the mediator then assume the role of arbitrator, ultimately are very significant. There's a risk of challenge to the arbitrator's himself or herself once they take on that role. But ultimately, the challenge particular is to the award and the potential for the award to be unenforceable on grounds of public policy, or potentially because the arbitration was not in accordance with the arbitration agreement. Now, I think that to some degree, these risks can be managed through a properly considered and drafted agreement of the parties, essentially embodying their consent after full disclosure of these kind of risks, and really putting into place sort of process-driven limitations that can try and essentially bolster that award against the challenges to enforcement that I've just mentioned. But these are not, I don't think we can ever say that those risks are completely avoided. There's always the potential for a party to argue, for example, that the mediator hasn't respected the agreed process and limitations, and that's potentially tainted ultimately the outcome of the arbitration. And I think that the bigger point for me is that once you have these agreed and suitable process limitations to try and minimize the risk on enforcement, as Mark says, do you still see those same benefits in the mediation process that you would have seen if the mediation process was kept separate from the arbitration and involved a different neutral? I think the point here really is that you can take steps, for example, to avoid the caucus sessions and to ensure that the mediation takes place in joint sessions only. You can put limitations on the evaluative role of the mediator, for example, to avoid any suggestion that the mediator is prejudging issues. But ultimately, in those circumstances, how can the trust and rapport be built between the mediator and the parties, so that the parties can really evaluate their positions realistically, which I would see as one of the more key features of mediation, and one of the key reasons why mediation is, as Clea says, so often successful. They really need to be in a position to bare their souls. And in a situation where the neutral would potentially become a decision maker, I really see that there's a limitation there, that you can't actually participate in the mediation in a way that you would do if it was a separate neutral. Whatever procedural limitations and process-driven limitations are put in place to minimize risk, the decision maker can't unknow the things that they know from the process of mediation. So I think I'll stop there, and Mark is welcome to chip in if he has any further comments.
No, I want to emphasize just 2 points right now. One is, as we continue the discussion, I think we should keep in mind that there are 2 forms of med-arb that we should be considering. One that is agreed in advance as part of the dispute resolution process, and the one that I'm slightly more in favor of, which is what I would call lane switching. When a mediation is convened, the parties gain trust in the mediator, but are unable to resolve the dispute through the mediation process, but then in the moment say, we both trust you, you're well informed, and we'd like you to proceed to determine the controversy. That's different, I think. I very much agree with what Hannah said, that when you put in the guardrails that are absolutely necessary to do a med-arb process, you, I think, perforce take out many of the most useful aspects of mediation. So when you agree that you are only conducting the mediation aspect in joint session, as is frequently agreed, or if you have caucus sessions, people are very much inhibited in what they're going to say. And you take a second look at the arbitrator's appointment at the conclusion of the process. So it's frequently agreed that at the conclusion of the mediation aspect, the arbitrator can say that she or he does not feel that it's appropriate to continue in the decision-making role, or either of the parties can, in effect, exercise a veto. All of those important and necessary guardrails really turn what we're calling the med part of med-arb into a very different kettle of fish than what people think it might be. And it's, as one of the relatively few people who does both mediation and arbitration, I rarely combine them because I think the process, particularly the mediation process, significantly suffers and you're getting a very different process than you would if you chose a best-in-breed mediator followed by a best-in-breed arbitrator. So we'll talk more about that, but that's the overview.
I like the term best in breed. I think there's opportunity for a new legal ranking system there. Yes, very interesting questions, Hannah and Mark. Perhaps cultural aspects to that, and we'll revisit that because to an extent that's going to depend on parties' attitudes to these things, which may be informed by which part of the world they're in. But standing your comments, Mark, what is the perspective of the ICC Task Force on this, given that you're on it?
So you're referring, Brandon, to the ICC Task Force on Arbitration and ADR.
I am indeed.
And the perspective of the task force, whose work is ongoing, it's preliminary, is that this is not part of our mandate. We are looking at ways to integrate settlement into the arbitration process, innovative mixing of modes, which is yet another task force that's out there, the Mixed Mode Task Force. But the hat switching or double hatting has been expressly carved out of the task force mandate. As Hannah and I will discuss later, I think we'll be looking at some important innovations such as mediation windows, parallel mediation, shadow mediation, all of which, in my view, are better alternatives that accomplish many of the same goals.
Okay. Thanks, Mark. I should say we'll move on or perhaps further into that area, but I should say that we have the platform there. If anyone watching has questions, there will be a Q&A session at the end. So do add comments to the live discussion on the platform, and we'll pick those up later on. So we've opened a can of worms, perhaps, with our interrogation of the subject. What are some of the factors that lead to the popularity of MedArb then in some parts of the world, certain jurisdictions? Take me, there's a cultural reluctance maybe in some jurisdictions. How do you see this?
No, that's absolutely right. Culture, I think, plays a big part in shaping attitudes towards MedArb in different jurisdictions, and in certain instances has led MedArb to be more popular in particular jurisdictions. I think especially in this part of the world, in Asia, there is generally a cultural preference for conciliation over adjudication when it comes to disputes. I'll just pause there to add a heavy caveat that it is often difficult and sometimes dangerous to generalize about culture. I mean, the Chinese diaspora has got billions of people worldwide, and it is at the same time difficult to say that an entire culture behaves in some sort of homogeneous manner. But it is still possible to glean some observations about the inclinations of certain culture towards certain types or certain aspects of dispute resolution over others, right? So at least in Asia, I believe, in my view, that there is certainly a strong cultural preference for conciliation over adjudication, and that stems from a cultural inclination towards maintaining harmony in any kind of a relationship. The interesting thing is that you do see that you do see this cultural preference translate in real life, right? For example, in recently reported statistics, 20 to 30% of CTEC's caseload, the China CTEC's caseload, 20 to 30% of that caseload was resolved successfully through mediation. And to pick up on something that Hannah mentioned previously on the risk of challenge and the risk of challenge to an arbitrator if an arbitrator double hats and the enforcement risk associated with that, we actually see, for instance, in Japan, that being dealt with. So for instance, Japan's arbitration law and arbitration rules actually actively encourage arbitrators to assist parties to settle their disputes amicably, and the JCAA mediation rules actually expressly permit a mediator to sit as an arbitrator in subsequent arbitral proceedings. So yeah, to sum up my observations on this, yes, I do think that cultural inclinations and preferences do play a big part in affecting the popularity of MedArb as a dispute resolution mechanism in certain jurisdictions more than others. And in my own personal experience, I definitely do think that there is a stronger reception for the use of MedArb as a dispute resolution mechanism in Asia over, say, for instance, the disputes that I've worked on or the clients that I've had in other parts of the world.
Yeah, I mean that's really interesting, and it's, I suppose, ultimately, as a lawyer advising clients, it's whether there is more likely to be, it's this fear of a procedural challenge, a serious irregularity, a breach of natural justice, and whether that we're more likely to see that in some jurisdictions than others, because ultimately the facts will be the same regardless of where your arbitration is seated. If you've got a mediator who is saying the same things to the same parties, it's how a court with supervisory jurisdiction would perceive that. So that and it's very difficult to anticipate that in advance, I guess. But going back to Hannah and Mark, this reluctance of practitioners in other jurisdictions where there is this double hatting, what is that seated in? How do you see that?
Well, let me start that out. I think certainly the U.S., where I'm sitting at the moment, presents the opposite end of the spectrum from Asia in terms of an aversion to litigation or adjudication. It's no secret that we're a highly litigious society here. That does not extend to an aversion to mediation. Mediation is really ubiquitous in the United States. Almost every court system in the US has mandatory arbitration of every case on the docket. And we see that, of course, reflected in the institutional arbitration rules, which increasingly are adopting mediation provisions. In the case of the ICDR, it is now an opt-out provision.
Sorry, Mark, there's mandatory mediation in the US courts.
That's correct.
Sorry, I think you said arbitration, but it's mandatory mediation.
Oh, I'm sorry. Mediation. Yes, I'm sorry. Mediation. Right. So the ICDR rule is now an opt-out rule. Every arbitration will be mediated concurrently unless the parties opt out, either in their agreement or in the process. The interest in mediation, though, does not extend to the process we're talking about today, to the MedArb hat switching process. I think you do, as you mentioned, Brandon, see some difference between clients and external counsel. External counsel, in my experience as a general counsel, are very risk averse, but it really is internal counsel's role to make the business risk decisions. And I think with full disclosure, the business risk can be assumed. So I don't think it's a situation where you can't do it. I think, coming back to the theme that Hannah and I do advance here, that it's just not the best process. Another example, I think, of an inhibition in the MedArb process is the great debate about whether a mediator should be facilitative, i.e. just facilitating the discussion between the parties, or evaluative, a more active participant providing views. And in a MedArb process, I would be very reluctant to provide any measure of views, because I'm going to be the adjudicative person as well. That's a very significant drawback to the effectiveness of the process. Hannah?
Thanks, Mark. I mean, just picking up on that last point, I think we do see different cultural approaches in terms of arbitrators, in terms of how far they're prepared to go to give the parties an indication of where their sensitivities are lying. And I think that there's a definite spectrum. And again, Techwe's already warned about generalizing or overgeneralizing, but I think we can see a difference between the common law approach, common law trained and traditional arbitrators, and perhaps civil law, and perhaps the civil law arbitrators tend to be further up the spectrum. I think everybody has a sort of point at which they're prepared to stop in terms of how much they are going to give an indication. And for some arbitrators, that's going to be, to the claimant, here's the issues on which I feel like I need to hear more, to the respondent, here's the issues, or just a collective bunch of issues at at some point in the process that they want the parties to pick up on and they want to hear more about. And in other instances, I think the arbitrator feels even more robust. So I do think that there are these cultural implications of how we approach arbitration, and then those play into the idea of the acceptance of MED-ARB. But I think all of us butt up, especially from the arbitration community, butt up against this idea that you are going to prejudice ultimately the enforceability potentially of the award, and that is the entire point of the process. So I don't think parties are against the idea of mediation at all, coming from from this side of the world, where I sit in London, and I think they're very open to different dispute resolution processes, but that's not to the extent that they're willing to actually compromise on how effective those dispute resolution processes would be. And I think with eyes opened by counsel or by their own research and consideration, particularly when looking at the kind of business case for how to resolve a dispute, as many of our more sophisticated clients do, they will always come down to the idea that if they're going to mediate, they don't want to add that additional risk. And why would they? The efficiency benefit is not there to introduce a risk that they don't need to introduce by having the same neutral involved.
Thanks, Hannah. Thanks, Mark. So some fairly strident criticisms of the potential for risk, particularly in Western jurisdictions, common law jurisdictions where you have a common law court with a supervisory jurisdiction, the risk that there might be an eventual challenge. How do you view that, Clea? How do you respond to that?
I hear what Hannah and Mark are saying, and I think those are very real and valid concerns, and I can certainly see them being concerns that would be shared by our clients if we were trying to advocate, for a MED-ARB process. But I think first of all, the double hatting issue needs to be broken down into two aspects. First of all, we've got double hatting in the sense of the confidentiality and without prejudice issue, which is clearly the main one, in terms of if or whether the same person can realistically be expected to engage in with confidential information that they might have gleaned in the mediation, and then go on to make to take on a decision-making role without being affected or prejudiced or in some way biased by that. And I think there's a kind of a second aspect to the double hatting concern, which relates to the idea that the skill set of a mediator is a very identifiable and particular skill set, and that the skill set of an arbitrator is a very different one as well, and whether or not somebody who has the ability to facilitate a discussion between two parties is going to be the same person or have the same skills who can effectively manage an arbitration. But looking at the first of those concerns, I think that we already within arbitration see instances where we ask arbitrators as decision makers to have certain information in their minds at certain phases of arbitrations, and then to put that information out of their minds for later phases. And I think that the evidence, in terms of evidence, that's probably the most clear example where parties object to documents being put into proceedings or object to the admissibility, and often arbitrators are asked to spend quite a bit of time considering information and documents, only to come to a decision that then they are not to take those into consideration. And so I think, and we trust arbitrators to do that. And so I think by extension, we can trust a neutral who has the role of mediator and arbitrator to have certain information that might be passed on to them in a caucusing situation within a mediation, without the guardrails of saying, no, we're not going to do that caucusing, everything's going to be in joint session, and then still be able to go on to an arbitration setting to then navigate that. I know it may sound a bit like a kind of a cerebral fiction, but I think if we ask arbitrators to do it already in one context, we can trust them to do it in the wider context of MED-ARB. And in terms of kind of the second concern about the skill sets of arbitrators and mediators, and whether the two can in fact be the same person and play that role, I mean, I think it's not at all unrealistic to imagine that there are these professionals that can do it. I mean, we've got a vast and incredibly skilled and experienced industry of neutrals, and happily that pool is growing with increased efforts in diversity within arbitration and ADR more generally. And I think that what we see is these kind of unicorns who can effectively manage a mediation, hopefully to a successful settlement. Then go on and be people who can efficiently, effectively, and capably lead, take an arbitration through to its conclusion and to a just and fair award is certainly possible.
Okay, so we're looking for best of breed unicorns now. So
Brendan, sorry, if I could just add on quickly there to what Cleo said. There is actually also a cultural element or cultural angle perspective to these concerns of double hatting, right? And as I already previously mentioned, in Asia, parties generally tend to prefer conciliation over adjudication. And the other unique aspect is that there is a certain sort of trust reposed by Asian parties in disputes in decision-making authorities, especially when they themselves were the ones who jointly agreed on the person to appoint. And in my experience, at least, parties actually prefer the mediator who sat as a mediator to go on to act as an arbitrator, because I think through the mediation process, a certain sort of rapport and trust is built up between the parties and the mediator that carries over into the arbitration process, and actually on some levels helps to reduce the acrimony in the arbitration process, helps to increase trust in actions or decisions that the mediator then go on to be arbitrator takes in the arbitration process. And in fact, funnily enough, actually reduces the incidence of challenge on the basis that the arbitrator has been biased or have expressed a certain views one way or the other, and so on and so forth. So there is, I think, a cultural element to whether or not parties are receptive to mediators then going on to sit as arbitrators in the subsequent arbitration.
That's very interesting. It reminds me of certainly my own jurisdiction years ago, hundreds of years ago. You had equitable arbitration where you're trusting a trusted person to come to an outcome, and regardless of, and there was a fluidity between dispute processes. Very interesting. So a minefield, but perhaps a minefield with a map and a path and guardrails in place, potentially. Let's move on then. So this system, what about disputes involving states or state-owned enterprises? What is it suitable? Is that a suitable mechanism in that scenario? Tekwi, do you want to pick up?
Yeah, sure. Sure. I think certainly, right. And this sort of carries on from what I said at the beginning. Regarding the advantages of MedUp in practice, right? I think those advantages are amplified in the case of disputes with states or state-owned entities. I mean, if you think about the type of contracts and business relationships that states or state-owned entities have with investors, it is of the precise nature that I spoke of earlier, right? Long-running commercial relationships. You have licenses for mines for 30 years. You have land, you have sort of manufacturing agreements for 10 years, 20 years. And that's because the nature of investment is such that it is a two-way street, right? It is not just for the investor to have an opportunity to make money. It is also for the state to benefit. And for those benefits for the states to materialize, the relationship necessarily has to be a fairly long and extensive one. It's not going to be the supply of goods for 1 year or anything of that sort. It almost necessarily has to be a fairly long relationship. And it is therefore in that context that I think MedUp is all the more so a suitable mechanism for resolving disputes between investors and states and state-owned enterprises. There is also another aspect to it, right, which is the idea of reputation, right? I think increasingly there are calls for states involved in arbitrations or even state-owned enterprises involved in arbitrations to be transparent about the process. For the hearings to be open, you have the UNCITRAL rules on transparency in investor-state arbitrations, right? And I think mediation is then now conveniently has sort of become a way for states to shy away from the publicity that necessarily comes with disputes with their investors, and to be able to resolve those disputes without having a huge spotlight shining on the disputes. And on some levels, I think it's to a very large extent, it actually promotes a more conducive environment for states to resolve their disputes with investors when you have mediation and when you don't have that spotlight. Because once you have that spotlight on states often feel compelled to take certain positions, to appear not to give up so easily, or to take certain hardline stance. So I think the use of MEDARB in state disputes actually makes it more conducive and promotes resolution of disputes in that sense.
And Cleo, do you concur with that in investor-state disputes?
Yeah, I would. I mean, if we take as a starting point an acknowledgement that MEDARB is no more or less than just a facilitated negotiation followed, if necessary, by an arbitration, then in principle, any dispute that could be assisted or even settled through negotiation is a good candidate for MEDARB. And that can, of course, be as true for investor-state disputes as it is for commercial disputes. Obviously, there's the consent issue. States need to consent to arbitration. And so we'd have to see a consent to MEDARB in the same way. And I think that would probably preclude what Mark's referred to before as the switching lanes. I don't think that you could get kind of partway through a process and then decide to do something. I think there would have to be kind of a state consent angle to it. But historically, many previous generation BITs already provided an option for mediation as part of the array of options for dispute resolution. I've even heard it suggested that the Iraq and Jordan BIT currently does provide for mandatory mediation as a precursor to arbitration. I don't know whether that BIT stipulates that the same neutral is involved in the mediation and arbitration, but you do have this idea that mediation can be used successfully instead of or even alongside arbitration for the resolution of ISDS disputes. To my mind, one of the common features of BITs is that they often have this mandatory cooling off period where parties are supposed to try and settle their disputes. But in practice, in my experience, those cooling off periods are kind of somewhat half-hearted exchanges of letters where there's no real prospect of resolving a dispute during that time. And then parties go, an investor starts an arbitration. But if we were to envisage a situation in which there was a consensual or pre-agreed MEDARB process, then that I think might give more teeth to the prospect of investors and states resolving their disputes before getting to arbitration. I think the point that Techme made, about transparency and confidentiality in the kind of investor-state dispute is a really important one, because there has been this perceived legitimacy crisis about investor-state disputes, about confidential arbitration processes that are very costly, taking place behind closed doors, and these arbitrations often can have some very real and significant consequences for countries, for economies, for populations, and so I think there is a kind of a query to be considered about whether or not states are going to be willing, given the great progress that's been made with the ancestral rules, with the Mauritius Conventions, towards legitimizing investor-state disputes and the transparency, whether or not adding in a process that kind of puts that back behind the curtain is one that states are going to go for. I guess it'll wait to be seen. ICSID, I think, just as a last very quick point, has in 2018 started the process of putting together some draft mediation rules. So clearly there is an appetite for mediation in this space. And those do kind of envisage MEDARB, various mechanisms to be used between states and investors.
Okay, thanks, Cleo. Another perspective, Hannah, Mark, do you tend to agree or tend to disagree for investor disputes, state disputes?
I think there are a number of points to consider in the context of investor-state mediation more generally before coming on to MEDARB. I think sometimes you find that there are delays in decision-making and difficulties in coordinating governments, so they're not as able to make decisions quickly as corporations, and this may limit the potential for using mediation or other forms of ADR, especially expeditiously, and certainly at the outset of a case. The state might, for example, have no budget allocated to the settlement of disputes, as opposed to the ability to actually pay a sum which is awarded against it by a tribunal or of a court. So obtaining approvals in the context of a dispute settlement that involves the payment of a sum by the state might be quite a challenging process. I think there's also a key point that Clea picked up on in relation to the nature of some of the investor-state disputes. If the dispute involves an industry or issue that's highly politicized or sensitive, transboundary resources is a good one, extractive industries or disputes that involve public health or local communities, it might be inappropriate to settle that dispute, especially behind closed doors, when it could potentially affect a large number of third parties. And I think states are conscious of the fact that they will have to essentially justify the outcome of the dispute to the general public and potentially in the media. And that might be more difficult if they can't be seen to have been compelled to do something and rather have been seen to have agreed to do it. I think there's sometimes a lack of incentives for settlement, and whether it's within mediation or outside of mediation in the context of investor-state disputes, ultimately it's for the investor generally to prove their case. So you do wonder whether the state can get enough perspective in the context of mediation to essentially see through that point and think about the ultimate benefits to them in settling a dispute. That said, I think my experiences are slightly different to Clea's in terms of how much can be achieved with the cooling off periods and the benefits that there are in terms of the engagement between the state and investor during those periods, and the meaningful nature of some of those conversations and meetings and how disputes can be resolved. I don't have the statistics, but I think that's probably borne out in terms of the number of disputes that are filed with ICSIT and then ultimately pursued.
Okay, Mark,
so there's a few points.
Thank you, Hannah. Mark, have you got any thoughts now? I would like to get a couple of questions from the audience as well, but do you have any thoughts?
I'd like to just take a moment to talk about some of the alternatives that I think accomplish the same goals. So I come back to really where we started. Efficiency, yes. Cost saving, yes. Mediation, yes. But why the same neutral? Some of the alternatives that I think present a much better process are things like parallel mediation or a mediation window, so that mediation unfolds concurrently with the arbitration, but with a separate neutral. Why not a separate neutral? What is the reason that people consider MedArb? One argument is it's more efficient. You've brought the mediator up to speed on the process. I would posit that the threshold, the burden of informing a mediator is not that great. Typically, what I see when I am mediating a dispute that's in arbitration is the arbitration pleadings or a short 10 or 15 page pre-mediation statement. I'll see the underlying agreements. I'll see the key correspondence. None of that is a great, huge package that's a great burden. But then you have all of the advantages of a separate neutral mediation. We can do shadow mediation where the mediator actually sits through parts of the arbitration. We can do substantive case presentations, the so-called Kaplan opening, during the course of the mediation after the first round of submissions, so that the parties are better informed and a mediator is potentially informed and brought into the process in a substantive way. So there are many alternatives out there that I think are better. The last thing I would add is I think that the pandemic and the very Zoom platform that we are gathered from all 350 people from around the world today shows that the burden of convening people for a very effective process is simply not what it was historically. So the supposed cost savings and efficiencies of MedArb, I think, can be addressed in other ways that preserve the advantages of a real mediation process.
Okay, well, we have a real debate going here. We're going to need a mediator to sort this out, or possibly a mediator arbitrator. Anyway, I want to get to a couple of these questions. This has been fantastic input from the speakers so far. We've got a couple of questions here. and I'd like to take them very briefly. So the first one, why is the EU not interested in joining the Singapore Convention, and does it affect the ARB-MED-ARB mechanism? And that's from Jung Nguyen, who's the director, I hope I've said that right, the director of ADR Vietnam Chambers. Clea, do you want to pick up that one?
Yeah, I'm happy to speak to that. So as I said earlier, the Singapore Convention, which came into force in 2020, has to date been signed by 53 or so countries, but it's actually only been ratified by 6. I think Belarus, Ecuador, Fiji, a few others, but not many of the big, not as many of the names as we might expect. And I think that's a surprise to many. Neither the EU nor, in fact, the UK have ratified the Singapore Convention. Now, I can give my own speculation as to why that might be. And I think that if we look at what's happening in the EU and with laws, with treaties in various areas, we've got the context of Brexit, we've got the context of ACMEA decisions, we've got the context of the ECT and various challenges to investment arbitration and dispute resolution within the EU. It might be that there's a reticence at the minute to ratify something that is potentially at risk of then being further discussed and decided that it's not appropriate, or that there is in some way an inappropriateness to the EU ratifying that rather than the kind of the different component states of the EU. And in terms of whether the Singapore Convention affects ARB-MED-ARB, what the Singapore Convention seeks to do is to give a legal structure for the enforcement of mediation awards, that settlement agreements that come out of mediation. But those mediations are not necessarily ones that are in another context. So if we have a mediation which is already within the context of an arbitration, then the Singapore Convention wouldn't necessarily be necessary, because the parties could take that settlement agreement to the arbitration, the tribunal that's already in place, and have that agreement, made into a binding award, which can then be enforced via the New York Convention. So I don't think the Singapore Convention is really aimed at ARB-MED-ARB in particular.
Okay, thank you for the very clear answer there. We have another question from Shannon Smith at Herbert Smith Freehills, which is, aside from preferences towards more conciliatory ADR methods that may be identified in particular jurisdictions, do the panel think that there are particular sectors or industries that might be more receptive towards processes like MED-ARB? Tekwe, do you want to take that one? Is there any particular sector you think where this is a useful process?
I think the energy and infrastructure and construction sectors are certainly industries that fit this description, that would potentially be more receptive towards MED-ARB. For example, like I've already mentioned previously, these are sectors in which contracts tend to be long-running, and disputes may arise in the process of performing the contract that need to be resolved fairly quickly or at all, and then the contract still has to go on. So for example, in the context of construction disputes, you see in FIDIC standard term contracts that there's always a provision that notwithstanding the raising of any dispute, the parties must still go on to perform their obligations. That cannot be used as an excuse to suspend the performance of their obligations. But what you then have, it's a very uneasy piece, if you will, where parties sort of are not happy with each other, but you've got to artificially park this to one side and still carry on and work together until the completion of the project, which in some cases might actually be 20 years later. So I think MED-ARB actually offers would be good in situations like this, because it offers you a fairly an avenue for dispute, a more immediate avenue for dispute resolution, rather than having to park this aside and revisiting this 10 years, 15 years later, even when maybe perhaps recollections are not perfect, documentary records are not complete. So you could potentially have a situation where, when a dispute arises, you have a MED-ARB clause that allows you to enter mediation immediately and do your arbitration when the project reaches completion, for example. That's one perfectly possible adaptation of the MedArb procedure. So yeah, there are definitely industries and sectors that will be more receptive towards this.
Okay, thank you, Tekwe. We're overrunning slightly. I understand we can have a slight overrun. We have one audience question left, which we'll take, and then we'll finish up. And that question is, there are certain jurisdictions with canons that prohibit double hatting. How would you reconcile this with the preference of the parties for the same neutral to do MedArb? And that's from Ali Manrique, who's OIC Chief Finance and Administrative Division, Office for ADR, Department of Justice. Not sure where. Any thoughts on that? I'm not sure which jurisdictions are being referred to there, but I suppose if there's a prohibition on double hatting, that would prevent MedArb going ahead. But do we have any thoughts from the panel? Hannah?
I mean, perhaps I can start. I think this takes me back to where I started with the enforcement risk, and in many of the disputes in which we see you are potentially enforcing in a number of different jurisdictions. So ultimately, your award needs to be robust enough to survive a public policy challenge wherever you find the assets that would satisfy that award. And so if you start from a position that jurisdiction takes against double hatting, and yet your arbitrator originally started with their mediator hat on, you are immediately, your award is at risk. And I think that may even be the case, notwithstanding any agreement between the parties that the arbitrator was entitled to wear that other hat. So again, to do the diligence in terms of the enforcement risk right at the beginning, when you're prepared to agree a procedure, when you put it into your contracts, for example, or even as Mark said, if you get to a position where you have engaged with the mediator, you've built a relationship of trust and rapport with the mediator, you feel like you trust that both parties trust that neutral to make an adjudicative decision, you still have to do that diligence to make sure that whatever happens is going to be enforceable. And I think that's too big a risk to bear.
Okay, thanks, Anna.
Brandon, if I may just add,
Yeah.
Obviously, if it's prohibited, it's prohibited. But I think those prohibitions are somewhat cultural, and they come from another aspect of trust, which is trust in the process. So it brings me back to what Tekwe said, that in some cultures, there is trust in this kind of process. I think in some of the Western cultures, that element of trust would be missing. Certainly my experience in corporate America is that it's not an introspective culture. When something goes wrong, when there's a bad result in a litigation or an arbitration, I would rarely hear we just didn't have a good case, or we did something wrong and we lost for that reason. People blame the process. So I think these rules, these sort of prophylactic rules, spring from an interest in protecting the categories of process, keeping things in their own lane, so that when there is inevitably a party who does not prevail, the party will at least feel that the process was fair.
Yeah, Brandon, sorry, if I can just jump in there as well, right? A practical suggestion to deal with this risk is this, right? To my mind, there are not many jurisdictions that would refuse enforcement of an arbitral award of its own accord for reasons that the parties didn't raise, right? There are very few jurisdictions that do that. And one way that, in my practice at least, that we often deal with the risks that Ali mentioned would be for parties to agree that there is to be no challenge to either the mediated settlement or any sort of, or if parties wish, for the consent award recording the mediated settlement. So that's one way of a very practical way of providing for it. Of course, there is the question of whether parties would agree to such a clause in the first place, right? But I think that might be a slightly separate conversation.
Yes, indeed. Okay, well, we've covered an awful lot of ground. We are up against time, I'm afraid, unless anyone has any last-minute desperate comment they wish to make. I think you've all given fantastic contributions and really thrown a lot of light on this subject. Clearly, there's still a lot of thinking to do on it, a lot of development, and we'll see how it all works out. And we look forward to these various projects telling us more about the future of MedArb. So thank you very much, everyone.
Thank you.
Thank you ever so much for taking part, and Brandon, thank you for your excellent moderator skills. Hopefully we'll see you in 2022 in Edinburgh. So just before we leave, just to point out a few housekeeping, the next sessions taking place will be at 3 o'clock, 2 roundtables. They are full. We limited the capacity so that we could have a face-to-face discussion with attendees. You can access these by going onto the virtual platform and just simply clicking on the session and joining, but you have to have had pre-registered to those particular sessions. The next webinar will now take place tomorrow at 9 AM, and you can see the agenda and add that to your event by going onto Swapcard as well. Thanks again, and we'll see you soon. Take care.